This case started out as a really sensible business deal. Classique coaches needed some land to operate their business. Foley operated a petrol station and had some spare adjacent land. Foley sold the land to the coach operators, and as part of the deal, they agreed that they would buy all their fuel from him. It's implied, but not really stated in the case, that Foley probably gave them a great price on the land because he knew how much petrol he'd be selling them. The relevant provision in the contract went like this: the vendor shall sell to the company, and the company shall purchase from the vendor all petrol which shall be required by the company for the running of their said business, at a price to be agreed by the parties in writing and from time to time. There was also a provision that if there was any dispute, the dispute would be referred to an arbitrator. For about 3 years, everything went swimmingly. However, Classique coaches then felt they could find a more economical fuel supplier. They gave notice that they did not consider themselves bound by the contract because the contract was not sufficiently certain and complete. In other words, they argued that because the price of the fuel had not been agreed, this was just an agreement to agree, and as such it could not be enforced. The court was not convinced. For one thing, the agreement had already been functioning perfectly well for 3 years, so they could hardly argue it was insufficiently certain or complete. More importantly, however, the contract contained a mechanism for fixing the price. If the parties couldn't agree, they went to arbitration. This saved the contract. Lord Justice Scruton put it this way: the parties obviously believed they had a contract, and they acted for 3 years as if they had. They had an arbitration clause which relates to the supply of petrol, and it seems to me that this arbitration clause applies to any failure to agree as to the price. There is to be implied in this contract a term that the petrol shall be supplied at a reasonable price and shall be of reasonable quality. In this case, again, we see the courts working to preserve the parties' actual bargain by implying clauses into the contract rather than striking it out as incomplete.